Good evening, everybody. I'm very pleased to see this nice crowd unexpectedly at a moment where normally universities are still sleeping, because it will take still some weeks, or at least 2 weeks, until the effervescent life of our academia will start again to spread over the world. We are more modest this evening because we just stay within a certain and a very important word for the understanding of where we live and what kind of problems, discussions, discourses we need to understand better in order to grasp the difficulties and also the chances of the future. Dr. Yavuz Aykan, as you have certainly understood by way of the invitation, has, as a very young scholar, however, albeit rather impressive vita to display. He conducts research inter alia in the fields of Islamic legal doctrine and Mamluk and Ottoman legal history. That's his specific field. He studied history, so he's a real historian, not just somebody who is interested in institutions as normal jurists are, who also become a little bit later on perhaps also historically interested. He's just a historian at Dokuz Eylül University in Izmir, as well as at Boğaziçi University in Istanbul. He subsequently received a diplôme d'études approfondies, what we call DEA. Ça n'existe pas en Allemagne, but it's an important means in between the master and the doctoral thesis in France. I think we have to think about the question whether we should not introduce this element. I think most of us who are familiar with the French system do appreciate this formula. It is an easier way, I think, to go then to the doctoral dissertation. At the Department of History and Civilization as at the École des Hautes Études en Sciences Sociales in Paris, where he also obtained his doctorate degree in 2012 with a thesis on les acteurs de la justice à Hamide et dans la province du, bon, je ne vais pas prononcer parce que ça sera trop difficile et trop faux, d'après les Siciles provinciaux du XVIIIe siècle. That means he's a specialist for this period. Unfortunately, we had to deplore the death of the director of this thesis, who is and was a famous figure in the French and international academic world. From 2005 to 2012, he was a lecturer at the Institut National des Langues et des Civilisations Orientales, INALCO, as well as at the Institute for the Near and Far East at LMU Munich. Most recently, Dr. Aykan was fellow at the International Research Center, Work and Human Life Cycle in Global History, another Käte Hamburger colleague at Berlin, and situated at the Humboldt University Berlin, where you conducted research on the construction of persona types in Islamic legal doctrine. That's, of course, a very, very interesting, fascinating topic. Since March 2013, then, as some of you know, he was fellow at our center, at the Center for Advanced Study Law as Culture. So this is a little bit to present you some elements of his biography. There is a lot of things that are lacking, especially also that after his stay, and this will be one of his last days at our center. And we are, of course, sufficiently sad to have a lot of incentives to celebrate this sadness together with you in common and with other friends of ours and who have to leave us. But you're going to another center for advanced study in France, the Institut d'études avancées à Nantes. In Nantes. And this is interesting to see that we have now a situation where in Europe those centers, another one will be created in Croatia in 2 weeks, take the role of bringing excellence and excellent research to an academic public in a rather new way. And this is interesting enough. So his research project at our center was about Islamic jurisprudence as a kind of language of debate in the early modern Ottoman context. So that's a very large but a very fascinating topic. Today his topic is another one, more specific, and I won't dare to go too much into it. I had the chance to have a look into the very interesting paper, and my proposition is just to give you the floor in order to tell us what and why you were so fascinated by this topic, and to tell us about your findings. So very welcome for the last talk during this time where you have been a very, very important fellow at our center. Thank you very much.
I thank the Professor Gebhardt for such a kind introduction, and also thank you for coming here for this, in order to listen to my presentation. And we have really very special guests, I should say, Professor Doris Abu Saif. She is very, very well known in the field from the School of Oriental and African Studies in London, and also Bethany Walker, another Mamluk historian, and who is situated now in the University of Bonn. Thank you for coming, and also my friends. Okay, actually I'm going to speak about a case that was, that took place in the 18th century Ottoman city of Amid. And this, my reading will involve, because of the integration of some juridical opinions, into the case, my presentation will involve a kind of archaeology that will go back until the 12th century. And also, we will need to go to different geographies, to not only in the Middle East, but also in Central Asia. So where we are now, we are in the city of Amid, the capital of the Diyarbakır province in the 18th century. But the city itself is called Diyarbakır today. And it is in the southeastern part of Anatolia, Ottoman Anatolia, which had a population in the time of around 50,000 people, which is quite a lot for an Anatolian town of the time, and surrounded by very beautiful Roman walls, very well protected, with 30 mosques and many madrasas, of both for religious learning and for legal learning, for what we call fiqh, Islamic jurisprudence in Islamic law. And intellectually, it was a very rich center. And this is, for example, one of the madrasas that was in the great mosque of the city for religious learning and legal learning. And now we come to our case. The actors of our case are, and this is not a divorce case actually, as the title implies. I think it is a case where the question of legal capacity is discussed through a divorce case, which is a little bit problematic legally. The actors of our case is the wife Hamide, her husband Seyyid Kemaleddin, Hamide's brother Seyyid Sunullah, and Hamide's proxy al-hajj Mahmud. The proxy, because Hamide sends her proxy to the court for her defense. On June 29, 1739, a woman named Hamide, a resident of the İckale quarter in the city of Amid, sent her proxy, al-hajj Mahmud, son of Mullah Ömer, to the legal court of the city to end her marriage with her husband named Seyyid Kemaleddin. As the judge questioned the parties, it turned out that, indeed, Kemaleddin had already divorced Hamide during an argument with her brother named Seyyid Sunullah. He uttered the divorce formula at once, 3 times. Go to your brother's house, I divorced you, which should be considered, according to the declarations of the proxy Mahmud, as an irrevocable divorce. Indeed, theoretically, such a clear and unequivocal statement of divorce formula does not require the intervention of the court in the case, because, according to Islamic jurisprudence, the dissolution of marriage is usually effective after such a divorce pronounced by the husband. As soon as the husband utters the divorce formula unilaterally 3 times, marriage is immediately broken in a definitive way. Hence, the fact that Hamide has brought her case before the judge reveals that her husband was refusing the consequences of his words. In other words, Kemaleddin was wishing to continue with his marriage in spite of the fact that he pronounced the divorce formula. The declarations of the proxy Mahmud runs as follows. 2 days before the present trial, Seyyid Kemaleddin, while he was the husband of aforementioned lady Hamide, had an argument with the brother of Hamide named Seyyid Sunullah. During the dispute, Kemaleddin said at once, 3 times, go to your brother's house, I divorced you, applying the irrevocable divorce, what we call talâk-ı, selâse in Ottoman language. The above mentioned Hamide even declared in the presence of Muslims and by citing them as witnesses that she was definitely divorced by above mentioned Kemaleddin. At present, I ask on behalf of aforementioned lady Hamide that what is necessary shall be applied according to the Sharia and according to the noble sense of the fatwas that she has in her hand. The legal formula talâk, divorce of a woman by her husband, is the normal case of divorce in Sharia. In theory, the married man has the right to pronounce talâk on his wife without indicating the reasons that provoke the talâk in question. As discussed by Muslim jurists, talâk may be revocable or irrevocable. Talâk revocable, which allows spouses to reconcile again, does not end the conjugal partnership immediately. This talâk can be revoked during the waiting period of women, what we call iddat in Ottoman, idda. According to the Hanafi jurists, actually Hanafism is the official mazhab, the legal school adopted by the Ottomans. This period includes 3 menstruation periods of the wife. When the woman no longer has her menstruation, this period is 3 months. The purpose of this period is to determine the father of the child if the woman is pregnant. It also provides spouses the opportunity to reconcile before the talâk. During waiting period, the man may withdraw talâk. If the man lets this time to pass without using his right to withdraw the talâk, the marriage is definitely broken. Then a new marriage contract is obligatory in case the spouses want to reconcile. In the case of an irrevocable divorce, these are really, a little bit complicated categories, but I hope I am clear. Okay. In the case of an irrevocable divorce, a marriage is dissolved immediately. The free man should pronounce the divorce 3 times on the woman so that the divorce is irrevocable, what we call bâi'n. For example, if a man says to his wife, you are divorced, the woman is divorced once. Then if the husband again says, you are divorced, the woman is divorced again. But this can be always revocable. It is always the 3rd utterance of the talâk formula that ends the marriage definitely. Expressions that make the irrevocable talâk must be unequivocal, sarih. If one who pronounces the divorce is using ambiguous or equivocal expressions, what is called kinaya, the couple must apply to a legal expert in order to clarify the situation. A new marriage contract between former spouses can be concluded after an irrevocable talâk only if the woman consumes another marriage with another man and repudiated by him. After the declaration of the proxy, the judge questioned Kemaleddin. He accepted the fact that Hamide was his wife, but declared for his defense, "I uttered those words in a state of madness and epilepsy." This declaration of Kemaleddin before the judge brought the debate into a field of disadvantage for Hamide, given that, according to Islamic jurisprudence, the divorce pronounced by a husband who is in a state of delirium or temporary madness is not valid. This jurisprudential principle is closely connected to the conception of legal capacity in Sharia. In this context, the full legal capacity is that of a free, mentally healthy, aql, and Muslim of certain age, baligh. Only under this condition, he or she is fully responsible, mukallaf, vis-à-vis the law. Actually, the word aql is a very central concept for the Islamic culture, and Lila Abulugot, she's a fascinating anthropologist, defines it as reason or social science. But it also, it also has the meaning, the meaning of seniority in the society or in a given community. After reaching a certain age, the individual is considered to be capable of forming decisions. As the utterance of the divorce formula was closely related to the intention of the man, he had to be in full possession of his mental and physical health. As such, it is obvious that with this declaration before the judge, Kemaleddin aimed at saving his marriage already jeopardized by him. Now I want to open a parenthesis in order to remind or underline something which is very important in Islamic legal procedures. According to Islamic jurisprudence, in a court proceeding, only the plaintiff is entitled to support his or her claims by witnesses in the case where the defense would deny the charge. If the plaintiff is not able to gather the necessary witnesses to prove his accusation, the judge asks the defense to take an oath for his denial. However, in our case, given that Kemaleddin advances another claim before the judge, makes him fall into a position equal to that of the plaintiff. In other words, by advancing a different story before the judge, he takes the position where he is expected to prove his argument, that is, his state of madness during the utterance of the divorce formula. As Barbara Johansen argues, this position is very advantageous because it allows the individual to present the strongest case before the judge, which is the testimony. However, after registering Kemaleddin's declaration and the refutation of the proxy, who claimed that Kemaleddin was not affected by the mentioned condition, the language of the court record notes the following highly formulaic sentence. As the proof of the legal capacity is more receivable than that of the madness, the production of evidence to support was requested from the proxy. Although we would expect that Kemaleddin had to have the right of taking the position of proving his madness before the judge, it is obvious that this sentence registered by the scribe in the court record rendered this legally null. In other words, this central rule in legal procedures was challenged by the court, rendering it completely without legal force or binding effect. Why such a particularity? Or why, according to the court, the proof of the legal capacity is more important than that of madness for the case in hand. As I am going to discuss, this point was a very small detail in the history of the development of Hanafi jurisprudence. It did not only change the course of our story, but it also gives us insights into the highly subtle litigation strategies followed by Hamide's proxy. By keeping this detail in mind, let me turn back to the case in hand. Upon the request of the judge, Hamide brought 4 males who would witness for the divorce and for the sanity of Kemaleddin. Their testimony in the court is registered as... No, sorry. I have to read. They say, indeed, 2 days before the present affair, above-mentioned Kemaleddin divorced his aforementioned wife, Hamide, daughter of al-hajj Mustafa, when he was sane and in full possession of his health. He uttered the divorce formula at once, 3 times, by saying, "Go to your brother's house, I divorced you." He admitted this in our presence. We testify on this matter and we even take oath. After the oral testimony of the witnesses, Hamide submitted 3 highly complex fatwas formulated by the city's mufti to the court. The fatwa is a legal opinion formulated by a jurisconsult as a response to the legal question of the individuals. The field of preparation of fatwas, which are not legally binding, was occupied by the city's mufti. I mean, mufti is not a judge. Judge is Käte. Mufti is responsible for preparing such advisory legal opinions. In the court of the city of Amid, the uses of fatwas by individuals shows that in complex legal cases, the fatwa had the role of guiding the actors of the legal dispute, including even the judge, towards a final verdict in favor of the one who brings the fatwa to the court. The fatwas were usually simple abstractions of specific cases with pseudonyms like Zayd and Amr, used instead of real names of the parties in the dispute. The question asked to the mufti was supposed to refer to a real problem to be discussed before the judge during a trial. These issues were to be formulated to allow yes or no answers. The first fatwa submitted to the court by Hamide reads, if Zayd says 3 times to his wife Hind, I divorced you, I divorced you, I divorced you. And in this condition, given that unequivocal statement is annexed to other unequivocal ones, could aforementioned Hind be considered triply divorced according to the Sharia? The correct answer is yes, as it is clearly stated in Qadehan, one of the most authoritative books of Islamic law. If a man says to his woman, you are divorced, you are divorced, you are divorced, then she is divorced triply. Here, the last sentence is quoted by the mufti from the book of Qadehan, which is the reference for this fatwa. The first fatwa submitted by Hamide clearly underlines the rules governing the divorce according to the Sharia. It mentions the basic fact that the divorce formula uttered by the husband should be unequivocal and uttered 3 times at once. By this fatwa, which is justified by the opinion of the late 12th century Hanafi jurist Qadehan, the Mufti of Amid aimed at reminding the court the ideal way of divorcing one's wife. It's like deduction. We start with a general problem. What should be the ideal divorce? But was the formula uttered by Kemaleddin as clear as in the fatwa mentioned above? The answer is no. That's why the Mufti, after having formulated this first fatwa, issued a second one in order to give the court a juridical reason why the statement uttered by Kemaleddin had to be considered as an irrevocable divorce. The second fatwa says, this is Qadehan. The second fatwa. If Zayd, in a moment of passion, says to his wife Hind, I divorced you, go to your brother's house. And since, according to the law, by saying I divorced you, one revocable divorce, and by saying go to your brother's house, one irrevocable divorce takes effect. And given that, in this case, the irrevocable divorce is annexed in the unequivocal, could affirmation hint be divorced only by 2 divorce utterances? The correct answer is yes, as it is clearly stated in Multaqa, one of the most authoritative books of Islamic law. And we are quoting the book. An irrevocable divorce is annexed into an unequivocal one. This fatwa is important for its content as well as for the ways in which it reveals the historicity of the development of the rules governing divorce in Islamic jurisprudence. Actually, I should really accept that this fatwa was really, gave me much headache, in order to understand why. Yeah, it took months to understand. And this fatwa is, let's say, legitimized by the book of Ibrahim al-Halabi, who was an Ottoman mufti in the 15th century. As I have mentioned above, in order for an irrevocable divorce to take place, the husband had to pronounce the divorce formula 3 times in an unequivocal manner. By saying only 1 time, I divorced you, the divorce could be revoked by the husband during the wife's waiting period. The same goes even for the pronunciation of the 2nd divorce formula during this period. However, what is striking in this fatwa is that it contains the expression, go to your brother's house, which is considered, according to the fatwa, as an irrevocable divorce. The fatwa also reminds us that an irrevocable divorce is annexed to the unequivocal one. I want to say it in Arabic. al-bâi'n mulhaq bis-sarih. Al-bâi'n mulhaq bis-sarih. An irrevocable divorce is mulhaq, annexed to the unequivocal one. At first glance, this fatwa seems to be like a Gordian knot. In order to comprehend this point, let me open a parenthesis and speak about this very specific point in Islamic law, which is closely connected to its historicity. We are in Bâi'n, in today's Afghanistan. And there is a very important article written by Seyyid Kemaleddin. He's a Turkish scholar, the expert of Islamic law. His article also, speaks about this, but in just a couple of sentences. And this was a great help for me for going to the source. The teaching of Abu Hanifa in Iraq, the founder of the Hanafi school of law, spread to Central Asia already in the 8th century. The city of Bâi'n, in today's Afghanistan, became the first major center of Hanafism. Bâi'n developed and maintained its own distinct identity from within the Hanafi school, according to Seyyid Kemaleddin. Though certainly not in complete isolation and without being influenced by the others. As a group, they formed the tradition of Eastern Hanafism as distinct from the traditions of Iraq, Western Iran, and other schools in the central provinces of the Islamic world. One particularity of the bâi'n interpretation, among others, was about the rules governing the divorce affair. By working almost like cultural anthropologists, bâi'n jurists articulated a new doctrine concerning the equivocal and unequivocal divorce formulas. They argued that certain expressions that could be considered as equivocal for Iraqi society could be unequivocal for another culture. In this interpretive process, they cited a number of examples in order to show that it is indeed the intention of the man that should be the decisive factor in the establishment of the validity of a divorce. As such, if in one culture an expression like "get out of this house" clearly reflects the will and the intention of the man for divorce, then it should be considered as unequivocal and should be annexed to an irrevocable divorce. As such, in our fatwa, what is cited in Arabic as an irrevocable divorce is annexed into an unequivocal one, refers to bâi'n interpretation of divorce and suggests that in the 18th century Ottoman Amid, the expression "go to your brother's house" clearly shows Kemaleddin's intention of divorcing Hamide. This is the reason why actually the Mufti of Amid integrated this point in his fatwa. This is Bel, just in the south of Oxus River. Our final fatwa brought by Hamide is about the discussion of madness. Undoubtedly, the argument of temporary madness during the pronunciation of the divorce formula was the strongest card in Kemaleddin's hand. However, the last fatwa aims at rendering Kemaleddin's argument ineffective. The fatwa reads, if Zayd at one time losing and at another time regaining his consciousness. This is very interesting because the fatwa is in Old Turkish, in Ottoman, but in order to describe the Zayd's state of mind during the divorce, they write it directly, this formula, in Arabic. Yajun taratan yufiq taratan. Zayd, who is yujin taratan yajun taratan yufiq taratan. I mean, this is the first time that I see a complete Arabic formula integrated into a Turkish fatwa. If Zayd at one time losing and at another time regaining his consciousness divorces his wife Hind and later on says that I divorced her in a state of madness and produces the necessary proof in front of the court. And the aforementioned Hind also produces proof showing that he, which means Zayd, was rational, and if in this case there exists a dissent, ikhtilaf, among the Hanafi jurists as to the validity of both proofs, could the judge of the case make a decision for the proof of rationality? The correct answer is yes, as it is clearly stated in Qunya, one of the most authoritative books of Islamic law. Mufti is citing again the book. The proof of legal faculty is more important than the evidence of madness. Do you remember this formula? We just saw at the beginning. This fatwa brings us back to the question that I asked at the beginning of my presentation, where Kemaleddin, as the defense, lost his position of having the right of bringing the testimony during the court procedure. As I have mentioned earlier, according to the Islamic court procedures, if the accused party did not deny but developed another argument against the accusation, he could then take a position like that of the plaintiff. In this case, he would have the right to bring witnesses to prove his counter-accusation. However, in our case, the fact that Kemaleddin could not gain this privilege during the legal procedure is closely connected to the notion of dissent among the Hanafi jurists and the ways in which Hamide and her proxy, Mahmud, transformed this technical legal detail into a litigation strategy. Before getting into a detailed discussion of this litigation strategy, let me ask a question. What is the nature of the disagreement in our case then? In fact, as I have underlined, according to the Hanafi jurists, the divorce pronounced by a man who is in a state of delirium or madness is not valid, as he is not considered as legally responsible for his actions. In this case, the most important point was that the man legally had to prove his madness by witnesses. However, in the 14th century, a Mamluk Hanafi jurist named Masud al-Qunawi is cited in our fatwa, who argues that, who articulated a different doctrine. Actually, on this particular question, I could understand it, but I didn't really, I couldn't get into this fatwa or this opinion in depth. So, but what is the main argument is here. Although I will be certainly taking up this point as this research progresses, my preliminary observation is that al-Qunawi established an analogy in his writings between the rules of sales contract and the rules of governing divorce. I mean, what he does is a casuistry. In other words, through his casuistry, he applies a principle governing sales contract in Islam to the rules governing divorce. He argues that in Hanafi tradition, technically, in a sales contract, if a man sells a property to another person and later on declares that the transaction in question is legally void, because he was in a state of delirium during the transaction in question, his claim is not considered to be valid. By departing from Hanafi tradition, al-Qunawi applies in his writing this principle to the rules governing divorce. He states that if there is such a conflict in a divorce case, the man's statement cannot be taken as valid either, since one cannot predict when he is conscious and when he is not. One cannot predict either if he is mentally healthy or not during the court procedure. In such a condition, what is legally more important is the statement of the wife and not the husband, who himself declares that he was in a temporary madness. Hence, he cannot be taken as a reliable man. Consequently, it is this opinion of Masud al-Qunawi that engenders the dissent among the Hanafi jurists. I mean, what is casuistry here? Let me just speak about some technical things. Here we have the legal application of the rules governing sales contract, at least in Hanafi tradition, to the question of the legal capacity of the madman in divorce, for divorcing his wife. The casuistry here, I am using the Bada Johansen's excellent article, Casuistry Between Legal Concept and Social Praxis. The validity of legal concepts are confined to certain boundaries, and the jurist has to determine whether the singular case in question falls within these boundaries or not. So here, what al-Qunawi does is to make an interpretation of divorce through the question of sales contract. But this still has to be developed. It's at this point that the artfulness of the proxy Mahmud becomes more visible during the litigation process. According to the Islamic law, in case of dissent among the jurists about a particular legal problem, the party who presents a fatwa, in case of a fatwa underlining dissent and authorizing the judge to make a decision, will always win the trial. Thus, in case of disagreement in the Muslim law on uncertain situations, in other words, in the absence of unity of opinion among the jurists on a particular legal problem, the judge, who is in charge of the practical field of law, renders his decision in favor of the party who presents with a fatwa that alludes to the disagreement in question. In our case, in spite of Kemaleddin's declaration about his madness, it was the proxy Mahmud who underlined the dissent with a fatwa. It was this strategy that rendered the most important card in Kemaleddin's hand useless. Finally, the judge pronounced his verdict in favor of Hamide. Now, I want to read you, I have a very short conclusion actually, it will not take much time. My conclusion, but I want to, Max-Weber's formulation of Islamic law has been really criticized by most of the Islamic, the scholars of Islamic law. But anyway, I want to repeat here because I think most of the time in our works, we neglect the operations of fatwas in the particular cases, because it is the fatwa actually which shows the jurisprudential capacity of Islamic law. So I want to quote Weber. And Weber says, Qadi justice knows no rational rules of decision. Muhtarisgründe. whatever, nor does empirical justice of the pure type give any reasons which in our sense could be called rational. The concrete valuational character of Qadi justice can advance to a prophetic break with all tradition. The more strongly the religious nature of the Qadis or similar judges' position is emphasized, the more arbitrary that is, the less rule-bound will the judgment of the individual case be within that sphere. Actually, in my case, this is my interpretation. Fatwas were case-based legal interpretations dictated by legal reasoning that was generated by the exploration and deepening of a singular case accessible to observation. As an official appointed from the imperial capital, while writing each fatwa, the Mufti had the task of translating the formal abstract language of jurisprudence into particular cases through a reading of the legal doctrine accumulated over centuries. This operation required the Mufti's ability to establish a dialogue between jurisprudence as formulated in the authoritative texts and the case in question through the writing of fatwas. In this sense, the Sharia was not a divine fiat as formulated by Weber, but a contingent zone of argumentation and social articulation in which legal questions were expressed by jurists. Looking at the ways these authoritative texts were debated, reformulated, and even made operative in the Ottoman legal praxis reveals that the historically contingent landscape of the Islamic legal doctrine constituted an open commentary, binding the social practice to the authoritative texts. Whether the sources of these texts were religious or not is entirely another question. Thank you.